Hi, welcome to PlanStrongerTV. I'm your host, David Holland. On today's program, we're going to talk about the importance of estate planning and some of the documents you want to look at for your plan. Our guest will be attorney Matthew Shapiro. Stick around. Welcome, ladies and gentlemen. On today's program, we're going to talk about the importance of estate planning. Have you done your planning? It's so important. You have to make sure things are set up. Now, it's very easy to put this off. I understand. It's not always a priority to plan and sit down and spend time either thinking or even working on our own mortality. It's not fun, but it's so important. So, you need to meet with an attorney, talk with them about your situation, and figure out what documents are appropriate for you. And we'll get into some of that on today's program. But I want to stress to you that it's very important to do it now. You can't wait until you die to do the estate plan. And you also have to be competent. You have to be of sound mind to execute any agreement or make a trust or a will or any of these other documents. So if you have not met with an attorney, or it's been a while since your documents were updated, maybe you've moved, maybe you've had changes in your beneficiaries, maybe a lot of things have done or changed and been different. Important to meet with an attorney and get those things updated. Now, ask around. You don't have to work with the first attorney you meet. Different attorneys have different backgrounds. Different attorneys charge different fees. Ask around, interview them, and it's important. You need to like them. You need to feel comfortable that they know what they're talking about, and you need to be able to trust them. They are working for you. They are your advocate. So share with them about your situation. Talk through what you're trying to accomplish. I know from my work as a certified financial planner and a CPA, and also as a certified trust financial advisor, that this is an area that is vital. It comes up every week with the work I do with clients. So take the time to do it. You'll be so glad you did this for you, for your own peace of mind, and as important, for your family, so that what you want to accomplish for them is done. Stick around. Very glad to have Matthew Shapiro in the studio with me today. We're talking about a very important subject of your estate planning. Do you have all of it put together? That's why I wanted Matthew to come in and be with us. Matthew's a practicing attorney. He's with the firm of Rice & Rose, and we're going to be talking about what are the essential estate planning documents that you need to have in place. So, Matthew, welcome to the program.
David, thank you for having me. I'm very excited to be here.
Glad you're here. Now, you're a local guy, graduated from Seabreeze High School here in Daytona Beach, and then also went to school, Florida State and Florida International for your law degree.
I've been all over the state of Florida,
right.
but born and raised here, and very happy to be back. Been back about 5 years now, actually.
Excellent. All right. Well, very good. Well, I've seen your work and very much impressed with what you're doing. So thank you for taking some time to be with me and the viewers. So I want to dive right in here because this is such a critical topic that a lot of people, quite candidly, they put off or they just don't want to deal with it because, as you know, estate planning and getting the right documents in place, it's about mortality. It's about the fact that at some point we're going to leave this earth. So before we dig into it, what would you say is the number one thing, one of the most important things people should know about estate planning in general?
Well, first of all, you're absolutely right, and it's a double whammy. And the reason for that is, one, legalese and legal documents can be complicated and can be overwhelming. So no matter what the topic is, most of the time people don't want to go talk to an attorney and get work started. But you're absolutely right with the issue of mortality and not only what your own life is going to be like, but what's life going to be like for others after you leave. But for that very reason, it's so important you actually get plans in place. Now, to answer your actual question on it, if you don't have an estate plan in place, the state steps in and makes one for you.
And what's that called? There's a term for that.
Well, it's actually called intestacy.
Okay.
And the state is well-intentioned. You know, their first goal is not to take your money or to come up with a plan that you wouldn't like, but they have to paint a very broad brush. They have to say, okay, what would most people want to have happen to their property or to have happen to children if they're minors? And we're going to make a statute on that and try and make sure that this covers millions of people's wishes. Well, as you know, it usually doesn't.
Right.
We're all different individuals. We all have different family dynamics, children from previous relationships, things that come into play where if you can actually craft your own plan, you can get the peace of mind you want of knowing my property, and also in some instances your body and your well-being are going to be taken care of in the way that you specifically want, not in the way the legislature thinks you may want.
Okay, that makes sense. Well, and I think a lot of people, it's just easy to put it off to tomorrow. Now, the thing, though, that a lot of people I know don't realize and done financial planning work, and I probably should have said, I'm not an attorney, ladies and gentlemen, and don't play one on television either. So I defer to Matthew and attorneys like him to help my clients. But one of the things that I think people don't really realize is estate planning isn't just about death. It's also about being alive and making sure that documents are in place that if you can't do certain things, somebody else can step in.
Absolutely. And, you know, I've been to your office before, David, and you have a little device I love. It's your crystal ball. and the fact that it is broken. There is no foreseeing the future. We'd love it if we could say to clients, well, probably around the age of 75 or 80, you're going to have a health issue, and why don't you come in at 65 and then we'll plan. But there is no crystal ball, and there's no way of knowing. And one of the things I'm sure we'll get into today is the idea that it's not just a will, it's not just a trust, it's not about your property, it can be about you. And that is equally important, because if you don't have the proper documents in place and you can no longer act for yourself and pay your own bills and handle your own finances, you're going to have a guardianship in place. And that is essentially where the court appoints someone to be in charge of your well-being, both your body and your property.
How about that?
And everything they do is reported to the court and monitored. So if you need a new air conditioning unit, if you need to be moved to a new, assisted living facility or a new home, you're going to need an attorney, you're going to need court approval. That's a very expensive process. So it's a lot about taking a little bit of time, money, and effort now and making sure that things are in place.
That's an excellent point, Matthew. So if you haven't gotten the will in place, the state of Florida has a provision with the statutes to make sure things are going to go a certain way. If you don't have the documents in place to make sure that somebody else can step in for you, then here again, the court, the state is going to say, all right, we're going to appoint somebody to take care of you and you as a person and your property. All right, let's dig into this in terms of the actual documents, because people hear so many different things, Matthew, about what they need. And I will tell the viewers, and I'm sure you can echo this, that it depends on your individual situation, what makes sense. But let's start with a general overview. So let's start with the things that somebody would want to have in place that would be most applicable during their lifetime. So to avoid a guardianship or to allow somebody else to step in and take care of things, whether if they can't or not, what are those documents? Let's just go through one at a time.
Absolutely. And so again, we're only talking here about things pertaining to you while you are still alive.
Okay.
And there are really three common documents. And the nice thing is, whether you are someone who has just a little bit of money or whether you're someone that has a substantial amount of money, those three documents don't change.
How about that?
They are a living will, a healthcare surrogate, and a power of attorney. So to break them down, a living will, I think it's been about 16 years now, but people out there may remember the Terry Schiavo case, a very famous case in Florida.
Sure.
What it really boiled down to was you had someone that was only being kept alive through artificial means like breathing machines, feeding tubes, and there was a split among the family as to whether or not that should continue going on. You had the husband who thought one thing, and then of course you had the parents who thought another. And what a living will does is it expresses your wishes if you're in those scenarios. Some people can be intimidated by it, David, because they think that, well, I'm placing it on a family member to make a decision.
Right.
You're not doing that. All you're doing is you're making the decision, and then you're designating who's going to carry out that decision for you if you're not able to do so.
So you say, this is what I want to have happen. If I'm in a persistent vegetative state, that's the terminology, then I don't want any artificial life-sustaining steps taken. All the person who's taking on, that's being named, what are they specifically named?
They're going to be your agent.
Your agent.
That, yep.
So all the agent does is really just say, yep, that's it. That's what he wanted. Here's the form. Make this happen.
Absolutely.
It's really like like a messenger.
And I'll tell you, the interesting thing, at least to me I find it interesting, is everyone knows the persistent vegetative state example, because that's usually the ones where people say, well, if I'm going to be in a coma the rest of my life,
right.
no thank you. But there are actually other scenarios under it, including a terminal condition. You could be someone who's been diagnosed with some form of disease or affliction where you know it is terminal. It may not be tomorrow, it could very well be 2 years from now, but it is a terminal condition. And what do you want to have happen if you're in a car accident and you're in the hospital and the only thing keeping you going are these machines? Well, you may live if you recover, another 2-3 years, but do you want to if nature would otherwise take its course? So there are some nuances within the document as well that an attorney can go over with a client to make sure it reflects your wishes.
And we're not talking about a death panel or some sort of thing. We're like, you're not going to make it more than a couple of years. Let's go ahead and put them down. That's not what we're talking about. We're talking about where you are not you. You're out of it. You may be, not to be too blunt, but you may be brain dead. You may be you're done, and it's just your body that's there, and it's being kept alive artificially.
Absolutely.
Okay. So that's the advance directive.
Yep, that would be the living will, which is also very synonymous with an advance directive.
Okay.
The next would be the healthcare surrogate. And this is actually, I think, the one that's used the most out of all three. It is day-to-day healthcare decisions. We're not talking about whether or not to keep someone living. We're talking about, do they need assisted living? Do they need surgery? Not only that, but getting access to their healthcare records, because we all know there are lots of HIPAA laws out there, and it's not enough to say they want me to make a decision. You have to have the information, have access to it. So really, it's a two-pronged document where you are naming, once again, an agent who's going to make day-to-day healthcare decisions for you.
When you can't.
When you can't.
So if you can make those decisions yourself, this person can't come in and say, no, I think he needs surgery. It only operates when the person can't make the decision. And the way I always try to remember this is that the living will is, I'm done, pull the plug. The healthcare surrogate is, make me better.
Exactly.
And make that choice for me when I can't.
Yes, and make my life the best it can be. And with all three of these documents, the idea again is that I'm not able to act. If I could make my own decisions, fantastic. We don't need any of these things. But if you're not able to do so, and it's not just because you may be in a coma, it could be, I'll tell you the most common one, David, is dementia. Alzheimer's, afflictions of the mind where you could physically be in very good health, but you don't necessarily know what you're doing at that point in time. And someone needs to step in and make decisions for you.
And that's where the healthcare surrogate takes place?
Yes.
Okay. And then you mentioned 3 documents. So those 2 relate to healthcare. I'm guessing the third relates to finances.
We're going to flip the coin, go completely off of healthcare and just talk about finances, and that is the power of attorney.
Okay.
Now, all these documents are powerful, but this to me is the most powerful document. It's extremely important that you find someone that you trust implicitly if you're going to name them under it. And the idea behind a power of attorney is to allow someone to step into your shoes and handle your finances. And most people think, okay, well, pay my bills. That's what we're talking about.
That seems simple enough.
That is the ground floor, but it goes much further than that, and it includes selling property, purchasing property.
Enter into agreements.
Enter into
So it's
contracts.
not just financial, it's actually empowering them to do stuff for you legally.
Anything legal or financial could be covered by it. Other examples would include suing. If you are in an auto accident, and I don't do personal injury, but just to use that as an example, and you would otherwise maybe need to bring a lawsuit because of that, but you're incapacitated, that would allow your agent to stand in your shoes and bring that forward for you.
Okay, so you might have one person who is overseeing and making sure you're getting the medical care you need, and another person is carrying out your financial needs and paying your bills or doing something as much as, being a party to a lawsuit on your behalf while you're, getting better. Your financial affairs are being taken care of as well. Those 2 can be the same person, or it can be different people as well.
Exactly, and it's a case-by-case basis. For some people, it makes a lot of sense to have them be the same individual. For other people, they may have someone in their family who's in the healthcare field, but they don't know finances very well, and they can't handle that very well. So in that case, it may make sense to split those roles.
Well, in a lot of cases, there are different people that people feel like would be better. My parents got very lucky. They have a son that's a certified financial planner, and then another son who is a registered nurse. So they won on both accounts. So we each have our areas of responsibility for their estate planning. So, okay, so those are the 3 documents that are involved when people, during their lifetime and while they're alive. Now let's talk about the other 2, one of which, of course, can be involved when they're alive, but let's talk about the ones that really are more about people's stuff and what they do. So the first?
Well, the first would be a will,
Okay.
a standard will, and the second would be a trust.
All right.
And I'll tell you, David, I think to have the best understanding you can have, it's important to take one step back and talk about what probate is.
Okay.
At least
Everybody wants to
very
know about
briefly.
probate.
So in Florida, when you own property with someone else's name on it, meaning it's co-owned, it has a beneficiary, or it's set to go to someone on the title, that asset is almost always going to automatically pass to the person just with the death certificate. Period. For all the other things, where there's not someone's name on it, it goes to what's called probate. And probate is a bit of a bugaboo. People are afraid of it. They don't necessarily need to be, but with good planning, there are ways to minimize probate or the financial impact it would have.
Any of the expenses.
Exactly.
Yeah.
But long story short, probate is essentially, it's a court case, usually non-adversarial, where all you're doing is basically two things. One, settling someone's legal affairs. So if they owe money to people, if in the middle of a financial transaction, a lawsuit, winding those things down, and two, making sure their property goes from point A to point B. So with the will's your roadmap. It's the instructions to the judge.
Okay.
Basically two things. One, who's going to be in charge of all this? The statute will guess who you want in charge, but that might not be the person you actually want.
Okay.
The will can designate your personal representative or executor who's going to be in charge. And the second thing would be how your property is going to go. There are some limitations within a will that the state says, okay, we can't completely disinherit a spouse.
Right.
But for the most part, you are free to designate where your property is going to go and in what percentages and what amounts.
Okay, that makes sense. So the will is, hey, I'm going to go through probate. This is what I want to have happen. Here's who's in charge. Now, why would somebody look to a trust in addition to or in lieu of a will?
Well, a trust has numerous benefits, and we're only going to, I'm
Yeah.
sure, scratch the tip of the iceberg on trust work. But essentially with the trust, you are giving property to someone during your lifetime, a trustee. And when we talked earlier about if something's owned by someone else or co-owned, it doesn't go through probate.
Okay, good.
So in this case, the trust is the owner of the property. There's no need for whatever property is in that trust to go through probate, thus avoiding the time and the
Right.
financial expenditures that go with it. Another reason is you have so much more control over how that property goes. With a will, it's just if I leave property to David Holland, it goes to David Holland, and it's his to do with as he pleases.
Not a bad thing, by the way, ladies and gentlemen.
Yeah. If I have someone in my family who maybe is not financially
Right,
responsible like
right.
you are, and I don't want to give them a bunch of money, I could say to them, okay, I'm going to have my trustee give them payments over a certain amount of time in a certain period.
So there's post-mortem, after a person's passed, control and planning that can be done, disbursements over time. And you and I need to do a whole show just on trust. But the idea is, I think one of the key things when people start thinking about the trust, it can be in addition to or instead of a will, but it's not necessary for everybody. It depends on what you want to accomplish, whether you need one or not. So just because somebody says, hey, maybe you need a trust, doesn't mean you need to incur the expense of setting it up, because it may be that you're just fine with a will.
As with most things in life, it's a cost-benefit analysis, and you have to meet with someone to talk to them about what do you actually own and what are your goals with it.
Sure.
It could be as simple as we get things retitled and you have a simple will and it's taken care of, or it could be the polar opposite of that. You may have a value where there are going to be tax implications.
Sure.
That's another reason you may want to do a trust. You may have a creditor situation. That would be another reason where you may want to have a trust. There are numerous things that may come up in your life where you may need one, and it's a great tool for many people.
Excellent. Well, I think a real key point, and we'll wrap up for now, is that you've got to do it today if you're going to do it. You have to be competent to write agreements and enter into these things. So that's really one of the key things that people need to be aware of, is they can't wait. They need to get this done while they have their faculties and can set forth what they want to accomplish.
Absolutely, and David, I know you and I could probably do a whole nother show just on pre-drafted template documents that people use, but it's so important. When you meet with an attorney, it's not that you're paying for them to write something up, it's that you're paying them to get their advice and an understanding of what your assets are and how you want them to go. And that's really the only way you can ensure that you're going to have peace of mind moving forward. And I know many attorneys are very good at giving people that peace of mind, not making it harder than it needs to be. So I'd really encourage, if there's anyone out there, you're thinking about having estate planning done, reach out to an attorney, call them, give them the time that they need, because I think they can really help you achieve their goals on those things.
Yes, well put, Matthew. Good advice. Thank you very much for being with us. And of course, ladies and gentlemen, go to PlanStrongerTV.com. A lot more information there about the program, but also more information about Matthew and his firm and what they're doing to help people with their estate planning. Thanks for being with me, Matthew. I really appreciate it.
David, thank you so much.
Thank you. All right, now it's time for our viewer questions. So, First question comes from John in Daytona Beach, Florida. John's question is, I have a fixed annuity that I am going to be inheriting from my father, and I want to know how to minimize or avoid, if possible, having to pay tax on the gain in the annuity. So this is a question about a deferred fixed annuity that's with originally $100,000 would put into the annuity. It's just $100,000 in cash. It's not from an IRA or some sort of tax sheltered account. So the $100,000 John's father paid tax on and then put into the annuity. The annuity has grown over a period of time to $150,000. That $50,000 in gain, John's dad has not paid tax on because you only pay tax on it when you take it out. So John's question is, well, look, my dad's getting older. I'm thinking I'm going to inherit this $150,000 annuity, and I want to know what my tax consequences are going to be if I receive that, and then is there any way to deal with the taxes? So the first answer is, when John's dad passes away, he gets the $150,000. He's going to have to pay tax on the $50,000 of gains. Now, the taxation on a deferred annuity is what's called ordinary income taxation. It's like any other income. It's not capital gain. So it might be a higher tax bracket that John might have to pay because that income will come in and be on top of any existing income that John has. So it's a great question because he's thinking ahead about, well, I'm going to pay tax on that. There's no step up. You sometimes hear about a step up on mutual funds and stocks, things like that, to where you don't have to pay tax when somebody dies. The value gets adjusted and there's no gain if you sell after they pass away. That is not true with a deferred annuity. So this $50,000 of tax is going to have to be paid. John's question is, well, how can I minimize that? He's really only got two options. There's not any way to really roll that over and defer it that long. His first option, of course, is just take a lump sum from the insurance company. He'll file a claim and receive a lump sum of $150,000. Again, the $50,000 would all be taxable to John on top of his other existing income, pushing him probably into a higher tax bracket. His second option is to take a 5-year payout. Now, that's more attractive probably in John's case because he's only going to have to pay tax on part of the money each year. So not a bad way for him to structure this. It's smart that John is thinking ahead and thinking about what's going on. Now, I have one more suggestion for John and his dad. While John's dad is alive, he has some additional options. He could have his dad start pulling some money out of the annuity and going in and pay taxes at his dad's tax rate because it's going to have to be paid no matter what. So I like that, and maybe take part of it one year, part of it another, and go ahead and move it out and put it into some other financial vehicle. So great question, John. I really like that one. The second question I have is from a gentleman who wants to take money out of his IRA and convert it to a Roth. Great question. I highly recommend considering that as part of any plan. But the question is, he's got to take his required minimum distributions out each year. And his question is, well, can I take that required minimum distribution that I'm required to take out of my IRA each year from my IRA, because the IRS says I have to, once you turn 70 and a half, can I take that amount and put it into a Roth? The answer is no. That's got to show up and come out as an RMD and pay tax on it. If you want to convert some of your IRA to a Roth, it has to be other additional amounts beyond your RMD. Great question, and it's practically speaking, though, you've got to take other money to do that. Now, one more thing I want to cover and talk about is the importance when we talk about estate planning, how important it is for you to talk to your family. You know, these are great questions that viewers are asking, and it tells me people are trying to work together and plan their finances, not just one generation, but intergenerationally. So the thing I want to share with you is it's so important to talk to your family. Have an honest conversation with them about what your plans are. You don't have to tell them every detail of your financial situation, but it's good for those that are going to be affected by your estate plans to have an idea of what you intend to have happen so that they're not completely caught off guard, especially if you're going to ask anybody to be your executor also called a personal representative, your trustee, have power of attorney. Let these people know what their roles are going to be so that they know what they will need to prepare for. Now, if you have a question for me or you'd like more information about the show, let me share some information with you. You can send your questions to questions@PlanStrongerTV.com, or just for general information, visit www.PlanStrongerTV.com. I hope you've enjoyed the program. Come back and tune in again.